Generally, the business records and the public records exceptions to the hearsay rule don't apply to government records created as part of a specific criminal investigation. But can those hearsay exceptions apply if the government's investigation was routine and not in anticipation of any specific litigation? The Eighth Circuit addressed this question in United States v. Lundstrom. Gilbert Lundstrom was the chief executive officer of Tier 1 Bank. The Office of Thrift Supervision, or OTS, was a federal agency that regulated banks. As part of its ordinary regulation efforts, the agency examined Tier 1 at least once per year, sometimes made additional inquiries, and prepared reports regarding its findings. During an annual examination, OTS discovered that Tier 1 had been covering up serious issues with its financial status, and the agency shut down the bank a few months later. Lundstrom was criminally charged with bank and securities fraud for his role in the cover-up. 2 other executives were also charged, but they pleaded guilty and testified against Lundstrom. At Lundstrom's trial, several OTS reports were admitted as evidence under the hearsay exception for business records. Other documents and witness testimony also presented much of the same material that was in the reports. Lundstrom was convicted and sentenced to 11 years in prison. Lundstrom appealed to the Eighth Circuit. Among other arguments, Lundstrom claimed that the OTS reports didn't qualify for any hearsay exception and shouldn't have been admitted.